topic for discussion today is a very important law that has been in debate for quite a while now, and that's the law relating to sexual violence in this country. Commonly, uh, people discuss, and we also hear in the media, is the offense of rape. However, rape is not the only offense that deals with sexual violence in India. We have various other offenses. Uh, Rape is, of course, one of them under Section 375 of the Indian Penal Code. Apart from that, we have various other laws. We have the Protection of Children from Sexual Offences Act, uh, the provision of Section 377, which is not now a law anymore, after the amendment of after the judgment in Navtej Singh Johar. However, we shall be discussing all these today, right now. And to begin with, the when we talk about laws in this country relating to women, we need to understand the background of these laws, why these laws have been in place and why they are in existence today. Now, and to understand, we need to understand the background and history of our country. Now, India has a history of women degradation in the society. Our society has been very regressive towards women prior to independence, and even today, for that matter, in some remote areas of this country, we can still feel that discriminations exist against women in the society. So to cover that up, we got the provision of equality under the constitution of this country in the year 1950, and to compensate for all the inequalities and the troubles that women have faced prior to independence, a special provision was made under Article 15, Clause 3 of the Constitution to make special laws to protect women from all such evils that existed prior to independence, say for instance dowry or child marriages, sati, and all these things. This provision under Article 15, Clause 3 of the Constitution became a bedrock for all these laws today that we hear about, say for instance rape, or protecting women from outraging modesty. Then the Domestic Violence Act, protection of women from cruelty within a domestic household under Section 498A of the Indian Penal Code, protection from sexual harassment, all these things. Now, these are laws that came into existence after that provision under the Constitution, Article 15, Clause 3. Now, when we realize all this, we saw that when the Parliament in this country, when the legislature started making laws for women under that umbrella of Article 15, Clause 3, they overlook, or they sideline, the entire male class in the society. So this is what we'll be discussing today. Our special focus would be sex laws, that is rape, and we had this law in Section 377, which is no more a law now, and the Protection of Children from Sexual Offences Act, and various other provisions relating to these laws. Now, when we talk about Section 375 rape under the Indian Penal Code, the very first criticism of this offense of rape under Section 375 is that it is gender bias. The provision under Section 375 punishes a man for forcing himself for sexual relations upon a woman. This is the definition of rape under section 375, for which the punishment is prescribed under section 376. So this provision itself is gender bias. The fact that section 375 has not taken into consideration rapes on males make it a law absolutely violative of the principle of equality under the constitution of this country. The fact that even in 2020 we don't have a law to protect men from sexual violence is really a blot on the on this principle of equality under the constitution of this country. Now that's the first thing with regard to section 375, that it is not gender neutral, and I think that the parliament in this country and the legislature must think about making gender neutral sex laws in India, protecting anybody, be it a male or a female, from sexual violence. That's the first thing. The second thing, the law of rape in India was amended in the year 2013 at the backdrop of the Nirbhaya gang rape that happened in December 2012 in Delhi. And after that, in February 2013, we got a new law, which is now the present law of rape in India. Now, what changes were brought about by these laws, I'll be discussing one by one. The very first being the punishment under section 376 for the offense of rape under section 375. Now under section 376, the punishment has now been enhanced after 2013 amendment. The maximum punishment prescribed now is death penalty. So death penalty as a punishment for the offense of rape is somewhat controversial. The reason being, especially in a country like India, because when we talk about death penalty as a punishment for any offense under the Indian law, we need to understand that death penalty can be given only in the rarest of rare cases, as has been laid down by the Honorable Supreme Court of India in the landmark case of Bachchan Singh versus State of Punjab. And if we talk about death penalty is a punishment prescribed for various of other offences under the Indian Penal Code. Rape is now one of them. We have 13 other offences for which we have 12 other offences for which the death penalty can be given under the Indian Penal Code. One of the most famous of them is section 302 IPC, murder, and the punishment for murder is either imprisonment for life or death penalty. Now, as I said, death penalty is given only in the rarest of rare case. Now, the reason why this punishment of death penalty for the offense of rape is a controversial one is because of a small provision under another law, which is the Indian Evidence Act. Now, the Indian Evidence Act of 1872 lays down rules and procedures that need to be followed for producing an evidence in a court of law. Which evidence is acceptable, which evidence is not acceptable. All these things, all these rules have been laid down to that law of the Evidence Act. Now, when we talk about Indian criminal jurisprudence, we follow the principle of innocent until proven guilty, which means that if A accuses B of committing a particular offense, then A will have to prove beyond reasonable doubt that B committed that offense. Until that time, B is innocent. Now, this is the general rule that is followed in Indian criminal jurisprudence. This general rule has certain exceptions, which are laid down as presumptions under the Evidence Act, wherein the burden of proof shall shift on the accused, which means if A accuses B for committing any of those offences that come under that category of exceptions under the Evidence Act, then now B will have to prove that he did not commit that offence. So the burden of proof will shift on the accused, and the prosecution can do away with just alleging the particular offense. And there are various such kind of offenses listed under the Evidence Act, and rape is now one of them. So what is ironical here is that when we take into consideration this provision of death penalty under the 2013 amendment, and we take into consideration this provision of presumption under the Evidence Act, what we realize is that on the basis of presumption you are giving death penalty to a person, which can certainly be said that it is the most bizarre provision that has been introduced via the 2013 amendment. So the first problem with regard to the laws on sexual violence in this country is that they are gender biased. Secondly, the punishment now that has been prescribed has no reasonable basis. Now the third thing is the misuse of this provision. When we talk about women laws in this country, we realize that most of these women laws are the most misused provisions in India because of that presumption under the Evidence Act. Now when I talk about women laws, I am talking about all those laws made under that umbrella of Article 15 Clause 3. So these laws are one of the most misused provisions under the Indian law in this country. To begin, if we talk about another very controversial law relating to women in this country is the law of dowry, domestic violence. Section 498A of the Indian Penal Code punishes someone for inflicting cruelty on a person on the women for dowry demand, and it has been found that it is one of the most misused provision under the Indian Penal Code. More than 90% of the cases filed under the offense of section 498A have been found to be false and fabricated. And rape is no different. As per one of the reports, in the year 2013 and 2014, it was found that almost 53.4% cases filed under the offense of section 375 were found to be false and fabricated. And so it can be said that no doubt about that, because of the presumption under this provision. Now this is after that amendment of 2013, so obviously that penalty clause of death penalty for the offense of rape also comes into consideration when we are talking about this misuse of this provision. So we need to understand that when we prescribe a particular punishment for an offense, we need to understand what can be the repercussions of prescribing that punishment. We also need to take into consideration that, okay, fine, you are punishing a person for one of the most heinous crimes possible. Rape is a very heinous crime, no doubt about it. But we also need to take into consideration that it is such a fragile law because of that presumptive provision under the Evidence Act that its misuse is inevitable. You cannot rule out the fact that this provision under the law can be misused to a great extent. So this is something that I think the legislators in this country need to take into consideration, because they are the ones who are making the laws. We cannot put the blame on the executive or the judiciary for that matter. It is the legislature in this country that needs to take all these things into consideration. And there is no harm in making a gender neutral rape law in India. As soon as it happens, all these problems can be set aside. It would become very easy. Now, having said that, another provision that I would like to discuss, which has been in debate for quite a while now, is the provision of However, before that, I would like to discuss another law, which is the Protection of Children from Sexual Offences Act. Now, the Protection of Children from Sexual Offences Act is a law protecting children, as the law says, children from sexual violence and sexual offences. So it is a law with the same nature of punishing the offence for the same nature as that under rape under section 375. However, a special law has been made. The ambit of the offence has been widened, because what has been taken into consideration in the Protection of Children from Sexual Offences Act is that the consent, as in section 375, consensual sexual relations are not punishable. However, under POCSO, consent will not be taken into consideration while punishing an individual for the offence as written under Protection of Children from Sexual Offences Act. And that's the reason why rape is not the term used under POCSO. The term used is sexual assault. So, however, when we talk about the Protection of Children from Sexual Offences Act, the criteria for determining a person as a victim under the Protection of Children from Sexual Offences Act is age. Alright, so age is the criteria, which means any person below the age of, as prescribed under POCSO, suffers sexual violence with consent or without consent, then such a or has sexual relations with any person with consent or without consent, if that person happens to be an adult, a major in law, then that person will be booked for the offence of POCSO, and the consent will not be taken into consideration. Now, this is a very bizarre law, because it is very common nowadays for teenagers to get into consensual sexual relations, and then when that relationship ends with the person, the child goes and files a complaint, an FIR under the POCSO, and the man goes behind the bar, and obviously consent is not taken into consideration. So he comes under the garb of the Protection of Children from Sexual Offences Act. Now, that's one thing. The second thing is that when we talk about the Protection of Children from Sexual Offences Act, though the victim in this case can be a male child or a female child, the offender or the accused can only be a male. So again, the gender bias gets highlighted. So as far as the POCSO is concerned, there are two shortcomings of the law. First is the age criteria that they have looked into without taking into the consent criteria, and the second thing is that again the gender discrimination is obvious in this law, that only a man can be booked for the offence as stated in the POCSO. Now, another law that I would like to take into consideration is the law section 377 of the Indian Penal Code. Now, a judgment in law by the Honorable Supreme Court of India in Navtesh Singh Johar has nullified section 377 to a certain extent. Now, obviously, Navtesh Singh Johar has its own backlashes and its own criticism. However, to begin with, when we talk about section 377, section 377 is a colonial law. It was a law that was brought about by the Britishers. It is a pre-independence law, and as we know that the Indian Penal Code came in the year 1816. So it's section 377 under the Indian Penal Code was a pre-colonial law, and what the law basically punished people for, if we go into a literal interpretation of the law, was for unnatural offences, for unnatural sex. And it was a very wide law. It punished people for having relations with it punished people for bestiality, sodomy, and all these things. Any not only same-sex relations, but it punished people for having relations with any non-human entity as well, any sexual relations with any non-human entity as well. So as time passed by, the people started opening about their sexual orientations, and homosexual relation are something which is very common nowadays. And this is the same plea that was raised before the Supreme Court of India. And prior to that, this was a plea that was raised before the Delhi High Court. And Delhi High Court in the year 2009 gave a very progressive judgment where it held that homosexual relations are are very normal, and if they are happening with consent, there's no problem in that. They are not punishable. However, the problem with that judgment of the Delhi High Court was this law of Section 377, which punished people for having homosexual relations with consent or without consent. So, when that judgment of the Delhi High Court went in appeal to the Supreme Court of India, the Supreme Court rightly overturned the decision of the Delhi High Court and said that yes, homosexual relations are punishable under Section 377, the erstwhile Section 377, and it was it was it was noted in that judgment that it is now for the Parliament to amend this provision in law. However, then ultimately that decision of the Honorable Supreme Court again was criticized a lot. Okay, the judgment came in 2013. However, after that, in the year 2016, this plea was filed by a group of activists led by Navtej Singh Johar in the Honorable Supreme Court of India, challenging the constitutional validity of this provision under Section 377. And then we came with that judgment in 2018, and now Section 377 doesn't punish people for having consensual sexual relations against the order of nature, which means homosexual relations are perfectly valid now. However, the problem with that decision is manifold. To begin with, since we have now recognized homosexual relations and they are perfectly valid and legal, where is the law to recognize their marriages? We don't have a law today to get for homosexuals, for people in homosexual relations, to get a legally registered marriage. We don't have a law for that. That's the first thing. The second thing, if an individual in a homosexual relation decides to have a child through adoption or surrogacy. Now, surrogacy, again, the law on surrogacy in India is very complex. We won't be discussing it right now because that's not the topic for today's discussion. But when such person, now since homosexual relations, people in homosexual relations cannot have children because that's not natural through through by themselves, that's not natural. So obviously the only way left to have children is either through adoption or through the method of surrogacy. Where is that law which now gives them the right to have a child in adoption or through surrogacy? The judgment is not talking about that. There is no other law either. And that's the second thing. So we don't have a law for marriage, for registering their marriage. We don't have a law for giving them their adoption rights. We don't have a law to recognize their rights of guardianship. When we talk about the law of guardianship in this country, we realize that a father has different rights, a mother has different rights. Now, what would be the case of both being father and both being mother? That is, so we don't have a law to recognize their guardianship rights. We don't have a law to recognize their rights of succession. And then we don't have a law to recognize their rights on maintenance. When we talk about maintenance, Section 125 of the Code of Criminal Procedure gives a wife the right to be maintained by her husband. So obviously Section 125 is based on the premise of a heterosexual relationship. It will not take into consideration homosexual relations. So we don't have all these rights. So this judgment, in my view, is incomplete, and anybody who is batting for the rights of LGBT community in this country must raise this voice. And I think this is what I want. We must raise this voice, and petitions must be filed in the Supreme Court of India with regard to recognizing these rights as well. And this is all that I'd like to discuss with regard to this book. This book, The Defective Sex Law of India, is available on Amazon and Flipkart, and the book is talking about all the loopholes and the shortcomings of the laws in this country, uh, legitimizing or regulating sexual relations in India. That's all I'd like to say, and I hope that people would like to purchase this book. It's available on Amazon, it's available on Flipkart. Buy this book, read it, get in touch with me. My email ID is available in there, and let's have a discussion on these laws as well. Thank you.